If it's all right with everybody, I'm just going to do a little sort of mini introduction about me and Wrigleys. I've noticed on the participants list, I do know a couple of you, but for those that you don't know me, so my name's Fiona Wharton. I'm a consultant at Wrigleys Solicitors, where I've worked for about almost exactly the past year, having joined last summer, although this is the second iteration of that, because I did used to work for Wrigleys about 10 years ago as well. We have offices in Newcastle, Leeds and Sheffield, and we're one of the leading firms in the country, really, working with charities and social enterprises. We have a team of over 20 dedicated lawyers just working with charities and social enterprises, so we don't do work with other types of organisations like some firms do. We are solely dedicated to it, and as such we've got a strong reputation in the field. It's also probably just worth mentioning that I am a trustee myself of a couple of charities, one fairly large that you'll all have heard of called Changing Lives, but also, and I'm just going to mention this, I'm also a trustee of VON, and this talk today about collaborative working is actually quite timely. We had a trustee meeting for VON last week, and obviously VON is doing lots and lots of good things about trying to support the sector at the moment, particularly as it does always, but particularly at the moment. And actually in various conversations that we've had, thinking about collaborative working and how organisations can look at things a little bit differently going forward, and how collaborative working might fit into a part of that, was one of the things that came up last week actually. So this is quite timely, I think, and certainly it's good to have a number of you on the call today who are interested in this potentially. So let's make a start, shall we, with the first slide. Great. If we go just to the next one, yeah, great. So just a kind of quick summary of what I'm going to cover today. So I'm going to think about what I mean by collaborative working, because it means different things to different people, I think. What might be the benefits of it, and certainly there are benefits of it. And also potentially there are risks, always risks if you're doing something a little bit different. Thinking about what some of the key considerations are. And also in terms of one form of, whatever type of collaborative working you're doing, there's probably some sort of contract that's going to be involved in that. And having just a quick think about the kind of types of clauses that you should be having a look at. That's not going to be definitive, because clearly each type of collaborative working initiative is going to be a bit different, but it might get you off to a fairly good start. So if we go to the next slide. Just starting to think about what we mean by collaborative working. So as I said before, it can be all sorts of different things, and I suspect that some of you are already doing it in some form or another, perhaps whether you realise it or not. Collaborative working can be quite informal. It can be pick up the phone to somebody, do you know about this? Can we share a bit of knowledge? That's great, that's helped everybody, let's move on. That's some sort of collaboration. So you've got everything from that to what's at the end of that list on that slide about a full merger or takeover. And I include that within the collaborative working, because clearly to get to that point of actually kind of completing a merger process requires a lot of collaboration between parties. And it is something that definitely when you look at the sector press, when you look at the Charity Commission guidance, when you look at some of the other organisations that are sort of talking about this these days, certainly they're predicting that there might be more of that sort of more extreme end of the collaborative working spectrum happening as a result of the various circumstances we find ourselves in currently. So apart from informal and the merger sort of process, there's all sorts of permutations in between. As I said before, they are often contract based, and they can be talked about in a number of different ways. So many people will talk about partnership working, which I have to say is something of a bugbear for lawyers, because partnership means something quite specific in law, but we understand when people are talking about it, they don't mean partnership as in a legal partnership, they mean a partner as in a kind of perhaps more colloquial kind of definition of that. So that's why we tend to talk about collaboration. And clearly collaboration can be in all sorts of different ways. It can be a short-term thing, it can be longer term, it can be about a specific area of your work in the specific area, it can be all sorts of different things. It can be driven by funding opportunities and commissioners wanting people to work together. It can be all sorts of different things. I mentioned service level agreement because certainly some forms of collaboration are more of a situation where somebody's delivering something for somebody else in order to kind of achieve a shared goal, and that usually entails some kind of engagement whereby somebody's contracted to deliver some kind of service to that other party. You then get situations where there's a more formal group structure arranged, and that can include setting up a new legal vehicle. So we usually talk about that in terms of kind of joint ventures. So that could be setting up a shared trading subsidiary. It could be setting up a project company. So all of these things can kind of form part of collaborative working. I just mentioned consortiums and coalitions. I could mention federations and all sorts of other things as well. They are obviously forms of collaborative working, but they tend to be on a larger scale. So, you know, you obviously have some organisations which are divided into federation structures. You have some big consortiums who are commissioned to deliver things, who perhaps are working across different sectors. So we'll touch on those as we go through today. So if you go to the next slide. Next slide. So I said I mentioned what the kind of benefits should be. So this is kind of the good news, bad news bit of the talk, really. So starting about thinking about the benefits. So in terms of your charity, your organisation, clearly what you're set up to do is to deliver your charitable objects for the public benefit. Everything else is secondary to that. So if you are looking to kind of do some form of collaborative working in one of those different ways that I mentioned just now, then whatever you do needs to continue to deliver your charitable purpose in some way. And I think that's sometimes, and we'll come on to this in the risks a bit more, that's sometimes where people can kind of fall down. And sometimes that's not helped by third parties like commissioners and funders, etc. as well. However, the key for you to think about is what is being proposed to us, or what we're proposing to do, in some way either going to maximise the benefits to our beneficiaries? Is it going to deliver our charitable purpose more effectively? And that charitable purpose has to be delivered for the public benefit. Is it going to create an opportunity for us to have greater impact in terms of delivering that charitable purpose? So, for example, because you're scaling up in some way, it's potential to reach more individuals, to publicise what you're doing more widely, to reach out to other new commissioners, funders, stakeholders, etc. So those are kind of obviously really key benefits that could come from some form of collaborative working. I think, however, the next two perhaps are some of the reasons why a lot of people do get involved in collaborative working, particularly when you get to the kind of merger stroke takeover stroke transfer kind of end of the spectrum, but not necessarily there as well. Certainly setting up joint ventures and things can help with kind of cost efficiencies. And I think the kind of the financial sort of emphasis of things at the moment means that this sort of collaborative working is probably what's going to be one of the drivers going forward. So thereby thinking about setting up vehicles that can kind of deliver cost efficiencies for organisations by working together more effectively. Or indeed, just because if you're working with somebody else, it might give you kind of more opportunity to get more funding from other and new sources, or indeed to help you raise fundraising if your organisation is one that does sort of fundraising events, etc. I think the other kind of key sort of benefit really is this thing around accessing shared use of resources and skills. So we'll all know that delivering charitable purposes or running your organisations between the staff, if you have staff, and the trustees can be quite challenging. Certainly trying to attract really good trustees with the right sorts of skills and experience can be very difficult at times. But if you know another organisation that is willing to work with you that perhaps has those resources and skills, that it might be a good idea to kind of share that knowledge and experience, then clearly some sort of collaboration can facilitate that. And then I just mentioned at the end here that I'm not just talking here about collaboration within the charity sector, i.e. one charity working with another charity. It could be broader than that. So, you know, it could be charities working with social enterprises, of course. It could be charities working with their trading subsidiary. But equally, particularly when you come to the larger kind of consortiums or joint ventures of some sort, increasingly it might be that you're working with organisations outside the charitable sector. So, you know, public sector bodies, private sector or companies, that sort of thing. And of course, they throw up particular issues for charities because they're not bound by delivering their charitable purpose for the public benefit. So for any charity, they have to be very careful that what you're doing doesn't stray into something that falls outside that remit. Okay, should we just move to the next slide? So, having said what the kind of benefits could be, you know, there are many potential benefits for organisations out there. The flip side of that, of course, is that there are potentially some risks. And I've alluded to one already, really, which is this thing about not delivering your charitable purposes for the public benefit. We often talk about this in the sector in the term that you'll be familiar with, I should think, called mission drift, which is whereby people, you know, perhaps the organisation has been around for some time, and over time it's become a little less clear what those objects are and how they are delivered. And that can be for a number of fairly valid reasons. And I said earlier that, you know, one of those reasons is because commissioners change their commissioning frameworks, and they say, well, you did deliver this for the, you know, an age range between, you know, 15 to 25-year-olds, but actually what we really want to do is now work with 10 to 30-year-olds. Well, that might not be your organisation. So you have to be quite careful if, you know, that's a fairly simple example, of course, but you have to be quite careful that you're not dictated to by other organisations. And that brings me on to the next point, really, about undermining independence. So it's a really fundamental principle of charities that charities have to act independently in order to deliver their charitable purpose. So trustees must be able to make independent decisions. And I think that's one of the key things to think about when you're thinking about working with other organisations, is to remain focused on your own governance and your own independence. And if a project, particularly if it's going to go on for some time, but even more short-term ones, has some kind of robust decision-making framework in place to enable both organisations to ensure that they can kind of manage their own independence and governance. Clearly, one of the key risks could be around risks to your finance, to your assets, you know, if it's capital assets or indeed to your income levels. For charities, that's a challenge anyway, most of the time. And I think the thing with, you know, entering into some other arrangement, there are financial risks, not least, you know, worst case scenario, the thing doesn't work out. But also most new initiatives will require some kind of financial input in some way, whether that's in terms of purely input of people's time and resources. So there's a financial cost to that, or indeed actually to some kind of physical money being handed over in terms of kind of some loan up startup funding or something. So I think for organisations, they need to think carefully. You know, clearly this is a duty of trustees to manage any potential risks and protect the assets of your organisation. And when I say the assets of the organisation, it's not just financial. Obviously, your reputation is really important as a charity. You know, we've just come through a few years in the sector where the general reputation of the sector has taken a bit of a hit for various different reasons. And the Charity Commission, and you know, if you look at things like the Good Governance Code, it talks about you know, protecting the wider reputation of the charity sector. I think that's debatable because obviously for trustees, their duty is to their charity. But clearly, if you manage the reputation of your charity, then the knock-on effect is that is helpful, of course, for the wider sector. So I think, you know, managing your reputation and taking steps to do that, whether it's thinking about your intellectual property, thinking about how kind of data is managed, but even just simply kind of making sure you've got kind of clear decision-making framework in place, really. The other thing is the impact any collaboration is likely to have on the resources of both staff, if you have them, and of the board. Don't underestimate how much time and effort it can be in order to get something new off the ground. So if we just go to the next slide. The other thing to kind of mention here is just a few kind of pointers that I've learned along the way from having been involved in a number of different collaborative working initiatives, whether they've been merger processes or whether they've been about setting up consortiums or just delivering kind of joint ventures together, perhaps where you've got an organisation that's a lead partner with multiple other organisations involved delivering a project of some sort. Clearly, organisations that are very focused on their own operation and their own purposes, it can be quite a challenge to match that with another organisation equally focused on its own purposes and operations. So you need to be quite careful that whoever you're hooking up with, there isn't some kind of culture mismatch. And I think you need to explore that quite carefully, because from experience, what can seem like a good idea at the beginning doesn't necessarily work out that way. And it can be quite a lot of time and effort to get to that point. So it's a good idea early on to get a lot of the key people on both sides sort of joined up so they know whether or not they can work together. Because what you don't want is some kind of personality clash that's going to really kind of hamper the progression successfully of your project. Equally, all of those things can lead to a communications breakdown. And as we all know, communications is kind of so key to anything that you're doing operationally. So it's making sure you have a clear framework for how things are meant to be communicated to the other side, making sure you know who your key contacts are. If you need decision-making group, make sure you've got that in place early on. I think the other kind of issue, can be kind of silly things, not silly things, but things like the IT systems don't match up. Getting to know whether that's going to be a case, if that's important for your project early on, can save a lot of time and bother. Of course, some projects will involve a few transfers of staff and things like that, potentially, particularly if they're kind of commissioner driven. So it can potentially trigger cheapy processes, which may have a knock-on effect in terms of time scales and timetables. And here, I think kind of was one of the kind of key themes of today is, whatever you're doing, however informal it is, however short-term, long-term, etc., it's so important to have a plan. Making sure you have a plan and making sure you're being strategic as an organisation is important and can save a lot of grief later on. It can also obviously help to minimise any potential risks to your charitable assets. And I think it's really key for your organisation to make sure you know what your charitable assets are so that you can protect them. So if you're an organisation that has property, you have your staff, you have potentially intellectual property in something, you have certain ways of doing things, you have knowledge about whatever it is, then take steps before you'd go into any kind of collaborative working to make sure you protected those, because it's too late after the event and if somebody is claiming that they own those assets. I think the other thing is people can kind of get swept away by a new idea, to have the opportunity to do some sort of collaborative working that they haven't done before. Don't again underestimate that you need the right levels of skills and experience and knowledge to do that. So if you haven't got it, it might be a good idea to source it before you kind of go ahead. And that could be either at staff level, but it could also, and people are fairly used to kind of contracting with somebody to bring new skills in if they need it for a particular project, but equally at board level, I think. So if you're doing something whereby you're setting up a new joint venture, and it's more of a commercial enterprise, even if it's something as straightforward as opening a cafe or a shop or something like that, if nobody on your board has experience of running those sort of things, then potentially that could be a problem. So just think about kind of what skills and experience you need to do. And of course, it's no bad thing to do a regular audit of the skills you've got on your board anyway. So if we can just go to the next slide. So this is quite important in terms of key considerations. Glass of water. Obviously, being part of the charitable sector, you're quite heavily regulated. So if you're looking at a new initiative, it is the case that you will need to think about, are you able to do what you're wanting to do? And the best place to start when you're thinking about that is looking at your governing document. So obviously charities can be structured in different ways, whether they're charitable companies, CIOs, trusts, unincorporated associations, and lots of other or types of organisations, but those are the main ones. You need to have a look at your governing document to make sure you have permission within it to do what you want to do. So, for example, if you want to set up a trading subsidiary, either on your own or jointly with another organisation, do you have the right power in there to do that? If you want to do some sort of collaborative working, do you have the power to do so? Equally, if you want to merge with another organisation, what are your powers around that? And some governing documents suggest that if you want to make any changes, you might need to go to the Charity Commission to do that. So it's, you know, if that is the case, then that can have really long-term implications for the timing of a project, because it takes quite a long time to deal with the Charity Commission getting consent. The other thing to say, as I mentioned, is obviously organisations can be both structured as incorporated or unincorporated. So it is sometimes the case, particularly if it's required by a commissioner or funder of some sort, that they will only fund a particular joint initiative if the party is incorporated. So if you are an organisation that's not incorporated, it may be that you need to go through that process before you can do what you need to do. And again, because that involves liaising with the Charity Commission, applying to them to register the new charity, etc., that can have 3 to 4 months implications or more, depending on how complex the incorporation is, on setting up this new organisation and therefore being able to kind of proceed with the project. If you're only looking at a short-term project, you have to question whether that's viable or not. Clearly, if you're setting up some sort of joint asset transfer type company or something like that, then it's worth doing. But you would need to be timetabled into the whole project plan. So I think kind of the first thing I would say is make sure you're familiar with a governing document. It is, of course, as a reminder, a good idea to make sure you review your governing document from time to time to make sure it's fit for purpose. And one of the key areas that you will look at when you do that is your charitable objects. And as I said earlier, charities can only do something that's within the remit of their charitable objects. Straying outside that a little bit can lead to what we call the mission drift. So you need to be clear what your objects are and make sure what is being proposed falls within them. And I've certainly come across situations in the past where funders have restructured their contracts that are on offer, thereby potentially meaning organisations are no longer fitting into that kind of remit, and that can be a problem, particularly if it's been one of your main funding streams previously. And at that stage, I think the best thing to do is to talk to the funder, really, if it is a funder that you've had a previous relationship with. The other thing just to remind everybody about is about your trustee duties. So when you're thinking about any kind of collaborative working, it is the case that trustees are probably going to be involved in the decision making around that, or they ought to be, particularly if it's for more long-term or more important types of collaborative working. If it's just an informal thing, it might not be necessary, but in most cases trustees should be involved, not least because trustees have to act strategically for the organisation, so they need to be involved in something that might take the organisation outside something that it hasn't done previously. And it's a useful reminder to trustees to make sure that when they're thinking about anything, they need to be thinking about acting in the best interests of their charity, making sure that what they do and what it leads to will not have any negative impact on their ability to have independent decision making. In order to do that, to act in the best interests of the charity. They will also need to potentially manage any conflicts of interest. So it may be that the opportunity you're talking about has arisen because of a contact from one of the trustees. If that contact is something that the trustee has an involvement in themselves, then it may be that they're not able to be party to the decision making around those particular initiatives because of their potential conflict of interest. I think these days regulators are quite hot on managing conflicts of interest, so you do need to be quite careful about how you view that and make sure you comply with what's in your governing document around it, but also if you have it, and most organisations should have a separate conflict of interest policy. And certainly if it's a new initiative, many of you will be familiar with having a conflicts of interest register. Make sure that that's kept up to date, because new initiatives might mean that something that although people might have declared potential conflicts previously, this one might not have come up. So it needs to be a sort of active document, not something that's just reviewed once a year. And it's just worth mentioning, of course, that for those organisations out there that are charitable companies, whilst all these things I've been mentioning here really are forms of under charity law, they're also under company law as well. So if you're a charitable company, which I think many of you may be, then you will need to think about this in terms of both your duties as a trustee of a charity and also as a director of a company. And whilst at the moment there isn't a penalty regime that the regulator, the Charity Commission, can impose, there is for company law. So if your trustee is acting outside your remit, potentially you might have some personal liability. And certainly you need to think about the negative impact of that. I think also you need to think about any kind of collaborative working that involves setting up a new type of entity, so some sort of joint venture or a trading subsidiary, something like that. That actually means it's some form of investment. Usually that will involve financial investment, and that takes you into another area of law around the kind of trustee duty of care to manage investments properly. So thinking about this quite carefully, just thinking about this in terms of another organisation I've become aware of recently, where it may be that trustees didn't have proper oversight of investments that were being proposed because it was being managed at a staff executive level. And I think trustees need to be very careful that in those circumstances, it could be themselves, not the individuals who are the managers of the staff or the chief executive or whatever it was, who will be potentially liable. It will be the trustees. So I think, it may be that I think most of you here today are probably going to be at the staff level of organisations, which is fine, but it's worth a reminder to your trustees that they need to be thinking about anything like this in terms of kind of risk management. Yes, definitely the risk management for the charity, but it could also be potentially managing their own personal risk as well. And then I've mentioned it again because I'm going to mention it a lot today. It's really important to have a plan and be strategic. If we can go to the next slide. So just thinking about more key considerations, I think with any kind of collaborative working, it's really important to do appropriate due diligence. Do the checks you need to do to make sure you'll be able to manage your risk. The Charity Commission guidance, and some of you will be familiar with the toolkit they have on their website in terms of collaborative working, talks about know your partner. And I think that's a good point. And that could be anything, whether it's know your partner in terms of another charity, public sector body, subsidiary, whatever, is make sure you understand what the implications of working with that organisation has for you as an organisation. That kind of due diligence needs to be proportionate. So if you've got a sort of short-term collaborative working project of some sort in place, you probably won't need the same sort of due diligence depending on how high risk it is as you would for a full merger, for example. So it's just worth thinking about what's appropriate and making sure your trustees have considered what's appropriate, and when they make their decision about that, they're able to justify that decision. I think that's really important with a lot of this, the decision making around it, and making sure you record the decision making around it is equally important as actually making those decisions. It may be the case that some of that due diligence that you do requires you to get external advice. Certainly if you're looking at a merger, it's very common to get either legal advice or financial advice, or both. But it may also be the case that if you're looking at setting up a forum or some collaborative project where you're the lead partner, you may want an external consultant to help you facilitate that in some way. So I think, again, it's about being proportionate to what you do and thinking really realistically about what expenses might be involved in terms of that collaborative working project. As I mentioned a few times, decision making is really important. So it may be that it necessitates having some kind of formal decision making framework. So that can be everything about making sure organisations know who their key contacts are and how the communication flow is going to happen, up to having a whole project board or a mutual steering group of some sort. And I think if you do that, then you'll need a terms of reference for that. Terms of references can be something that's kind of drawn up on the back of an envelope, or they could be something that is quite formal. And certainly in some cases, funders or commissioners will look to see something that is quite robust, because obviously for them it's about managing their money and ensuring that they get their outcomes that they're looking for. And the people who are going to be responsible for that, particularly on a day-to-day basis, are that steering group. So I think kind of doing all of those things could be important steps to get right early on, and then you've got the framework set so that you can run the project effectively without having to revisit that too much. I mentioned planning again, because planning is just helps you to avoid quite a lot of the problems that might otherwise happen. I think the other thing, and I mentioned this one now, particularly because obviously a lot of organisations are looking at kind of different ways of working, ways to kind of explore opportunities that might arise from the current situation, or look at how to deal with the various challenges that have been thrown up. And they might be thinking about things in terms of generating unrestricted income because funding streams have dried up or sponsorship opportunities have dried up, etc. But I think, we had this a few years ago, I think, where people were quite tempted to set up trading subsidiaries to help them generate unrestricted income as funders decreased in what they would do in terms of funding overhead. And I think you just need to be careful with that to make sure that what you're proposing is required. So if you're setting up some kind of commercial initiative, for example, then it's important to have done your market research. And in some cases, it might be important to have done some stakeholder engagement to make sure everybody's on board with what you're proposing to do. The decision-making framework is important. So having that kind of project board in place early on is key, potentially, to the whole organisation. I mentioned the resource implications previously. From experience, it can be quite difficult. Trustees are obviously volunteers, so setting up one of these, particularly if it's a larger kind of project of some sort, can have really big implications for individuals who also try to juggle their working lives, their children, their families, or whatever it is. So I think you do need to think carefully about implications of that and how that's going to impact on your decision-making timeline, who might be involved more in the steering group and who might be involved more just at the kind of sign-off level, etc. And make sure that you can kind of manage expectations realistically. And of course, when you're setting up projects, etc., and even as they develop and as they are delivered, just to keep everything under review as you go. We go to the next slide. So I said that I would talk a little bit about the different types of contracts that you might come across when you're thinking about working with others. Many organisations think that the way to go is down a memorandum of understanding. It sounds very legal, but it isn't, in fact. It has no legal basis, really. An MOU is simply a record of an understanding about what the parties are thinking of doing. It's not actionable in law. Similarly, with heads of terms, it's really a record to get people understanding that they're on the same page. And neither of them should be at the expense of having a full agreement. They both have their uses, and it can kind of help to solidify people's commitment to a particular project. And you often see them in a merger process, for example, early on. but it shouldn't be at the expense of having a proper agreement drawn up that is fully signed and dated and legally watertight. Service level agreements I mentioned earlier. So that's usually where you have, for want of a better expression, a parent organisation that's contracting with others to deliver particular services, and clearly that's a form of collaboration. And we'll come on to the kind of different types of contract term that you might see. Collaborative and partnership working in terms of a true kind of partnership of equals, if you like, where people are kind of jointly delivering a particular project, setting up a funding initiative, delivering a joint venture, etc. They will need a proper written agreement. I think it's too much risk for organisations to try and do things without an agreement. Although the final point on this slide is something just to be aware of. People always talk about contracts in terms of written contracts, but in law you can have a contract made verbally. So whoever is kind of negotiating the collaborative working project that you're talking about needs to be very careful that they're A, delegated to make decisions and contract on behalf of the organisation, and B, be wary of what they say and how they say it, because it may be that they've created some form of contract. Of course, it's much easier if you've got written evidence, if something goes wrong, to go back on that. But even if you've got an email chain, for example, it may be, for example, if something got tested in a court, they might find that the organisations had contracted to do something, but potentially without meaning to. So I think just be careful about thinking about what a contract is or not, and take advice if you're not sure. And then the final thing just to mention on that slide is obviously mergers and transfer agreements are very formal arrangements, so they will need some sort of documentation. Mergers, is a talk in itself for another day potentially, but because they can be structured in different ways themselves. But if it's going to be a full kind of charity A plus charity B to converts to charity C, or charity B transfers all its assets to charity A, then clearly there's going to need to be agreements in place there, particularly if there's staff and property, etc. involved. Sometimes mergers happen whereby an organisation agrees to become a subsidiary of another one. So whilst you don't need a merger agreement as such there will need to be various resolutions and things in place. So it's just, if you're thinking about that sort of thing, just be forewarned that there's probably going to be quite a few steps to look at there. Next slide, please. So finally, just sort of coming on to some of the kind of key terms that we might think about in terms of contracts. Every contract is, of course, different, and you'll see different things in different organisations. So this is a fairly generic and definitely not definitive list. But I just wanted to mention a few things to get people thinking about it. And clearly, again, doing a kind of contracts session is potentially a whole session in its own right. But anyway, just thinking about contracts. So I think sometimes organisations forget to identify themselves clearly. So quite often people talk about themselves in a kind of colloquial way because they've got a trading name of some sort, etc. But for the purposes of a contract, you need to be talking about your formal names. And the best ways for charities to identify themselves is to reference their charity number as well. Because whilst you might change your name, you don't change your charity number generally, unless you incorporate, of course. Having a kind of clear statement of what the purpose of the contract is, what the relationship is going to be about, is important. And then obviously it's really key to set out what the roles and responsibilities of each organisation in relation to the relationship is going to be as well. And there's usually quite a bit of focus operationally on what that is, but that should be incorporated within the contract. The terms of the contract is important too, because there's different ways of looking at them. So it could be that you look at something that is a short-term project for a year or something like that. It could be something that's meant to be kind of going on for 2 to 3 to 5 years. It could be something that's done on a rolling basis that it is only terminable on sort of various kind of trigger points, but is otherwise going to be ongoing on a fairly sort of permanent basis. But you just need to be careful about what those terms are. And equally, taking us on to the next point, therefore, how a contract is terminated. I always say with these sorts of things, particularly with collaborative working, it's really important at the beginning to have your exit plan and to think about what the consequences of that might be. Taking us back to what we were thinking about in terms of trustees managing risk, clearly not all collaborative projects come off, sadly. So it is the case that some will fold for one reason or another at different stages of the process. And so organisations need to be clear what the impact of that is and how they can extract themselves from an organisation, from a venture. At the moment, of course, we've been looking at quite a lot of different kind of initiatives which have been impacted negatively because of the pandemic and therefore haven't been able to go ahead. So clearly thinking about kind of how that might impact on your consequences, albeit none of us were able to predict this, it is important, but those sort of force majeure provisions might be helpful to you. But equally, if there are issues around material breach of a contract on either side, because one organisation is no longer able to deliver for one reason or another, then you will need to have kind of clear termination provisions within your contract from the beginning. Payment usually gets quite a lot of focus, clearly what the amount's going to be, how it's going to be paid, what any clawback might be. So usually that part of the contract is fairly up to the forefront and well documented. I think the other kind of thing that people focus on too is the monitoring reporting. Clearly, if your project is driven by a funder or commissioner of some sort, they will require their own reporting back. So that needs to be passed through to whatever your project is. But equally, if you're setting up, just a project group to do a merger process, then, the boards of those respective organisations will expect some kind of reporting back. But it's just important to make sure you've got that factored into the kind of roles and responsibilities of the organisation or a decision-making group or the key contacts or whoever it is. Which leads me on to the decision-making and dispute resolution. As I said, not every project comes out well, so it needs to be clear how any kind of problems are dealt with and how that's scaled up if it's not resolvable early on, and the consequences of something if relationships break down. So I think kind of thinking about how you would manage that, even in the fairly formal arrangement, is important to manage any risk. And then finally, I was saying this to somebody the other day, because they tend to always come at the end of a contract, the sort of warranties, liabilities and indemnity provisions. So you spend ages thinking about all the other stuff, and then you get to these, and these are the bits that lawyers love, and they can be the bits that are most heavily negotiated, and can have the most impact on your relationship with another organisation. So if you're in a project or a relationship or something whereby you need quite extensive warranties, liabilities and indemnities, then I think probably at that stage you're going to need to be taking legal advice, because they can be quite complicated, and there's huge potential for them to be able to get it wrong, and thereby actually do more harm than good by having them in. So that's kind of what I wanted to say on the kind of key contract terms. And then finally, just if we go to the last slide. So I'm just going to say just a few things in summary, really. I like this 5 Ps thing: prior planning prevents poor performance. I think there's sort of colloquial versions of that too, but I think that's really important. Whatever you're thinking about doing for trustees, for charities, managing risk is really important, and the best way to manage risk is to do your preparation properly. So I think for organisations as well, and I'm sure this is going to be the case going forward as much as anything, people should try not to be too reactive. If you are able to think more strategically, more proactively about what's right for your organisation and act in its best interests, that's going to be much more helpful. So being strategic, thinking about your strategic plan, reviewing your strategic plan regularly, in light of current circumstances, in light of future opportunities or challenges, is important. But if you do it as a proactive thing, then that is going to help an organisation be much more robust in terms of meeting those challenges and opportunities. And as I said, keeping everything under review as you go through a project, whatever type of project it is, and making sure it is still fit for purpose for your organisation is going to be important. So I think the key message to take away today from collaborative working session is, yes, it can have lots of opportunities. So don't think, gosh, there's lots to think about there, lots of potential issues. It can have lots of benefits, but in order to kind of maximise those benefits and give your organisation the best opportunity, it's really important to make sure you've planned properly and managed any risk properly. Thank you.